Hello, everybody, and good afternoon. I'm Dianne Drain, co-chair of ACBC and chair of the CLE committee, along with Lisa Thompson is my ghost sub-chair, co-chair of the CLE committee. So anyway, what we're going to be doing today is going through Chapter 13 in Southern Arizona and how that works. Meanwhile, let's do a little bit of housekeeping. Number one, I'm going to be posting the materials to the program, so it'll be on the chat, but I'm also going to upload them over to the ACBC website, where you will find a recording of this on our YouTube channel, and along with that, and then you can get the materials. Secondly, as far as questions for Lisa, you're all on mute. Please post your question to the chat. I'll kind of keep an eye on it. Sherry Lewis, Ron, thank you very much. That was our NIC in my crystal ball. So anyway, so post your questions. I'll kind of watch them and in tune with Lisa where she's at, may interject them. But certainly she is happy to answer your questions if she didn't get to them during the actual presentation, then after that. So why don't I think that's it for housekeeping.
And
So
I'm going to ask that everyone turn their cameras off because I have a hard time seeing my actual presentation when you're on camera. Plus, we're recording it.
yeah,
So Diane, if you could help people that are having problems as the host, if you could just turn it off because I need to be able to read my materials.
you
So
got it.
thank
No
you. Not that I don't want to see happy faces.
problem.
As Diane said, my name is Lisa Thompson. I have been practicing in the bankruptcy world for about 30 years now. And I recently became the Chapter 13 staff attorney. Craig Morris retired, and I took over his position, but I am not Craig. Um, I I have found this job to be a challenge, but in a good way. I had no idea about many things about the Chapter 13 trustee's office. So this is based on what I've seen for the last 8 months. I have my handy dandy book here. I was taking notes the whole time of like, wait, what? Or, oh, I need to tell people that. So my learning curve has been incredibly steep, pretty much like this. I think it's kind of going like that, but there are days. Um, there have been things that I knew. There are things I wish I had known, and there are things that I'm still learning. So some of you will already know these things. You might see some of what I say as very basic, but you would be surprised how many folks do not know some of the things I'm going to talk about. So in order to make it to the book, it was either something I didn't know or something that I have seen at least 5 times, if not more. So, because everything can be an aberration, I didn't want to bore you with those, but shockingly, um, I have seen these things quite a bit. And so maybe it's just a reminder, maybe it's something new, or maybe you're going to be one of the lucky ones that sits on this presentation and is like, I knew that, I knew that, I do that, and then fantastic. I'm giving you gold stars. Um, we want everyone to be on the same page. So I don't want to assume that anyone knows something about the Chapter 13 trustee's office. And so that's one of the reasons why we created the seminar. Um, you are always welcome to reach out to me. I've posted my email address. I only work part-time, so most of you have my law firm email address. You're welcome to reach out to me there. It really doesn't matter. Always copy mail at dcktrustee.com, especially if there are documents that you want signed. I'm generally in the office on Monday and working remotely on Tuesday, and then the rest of the time I I look at and respond to emails as I can, but Mondays and Tuesdays are my big days at the office. So just keep that in mind because invariably someone will email me on Wednesday and then I don't get back until Monday and I look like I'm not paying attention. So here is my list of websites you should use. I put them, I don't know if in the materials you can click on it and it goes to the website, but you most certainly can cut and paste. Um, I am going to give Dianne the most of the forms I talk about today, but this is the first one is the trustee's website, and there are a lot of documents there that are fillable PDFs or in Microsoft Word that you can fill out for the things that we need and we want. We're also going to be posting this video there, and it will be available for you to look at your leisure or um, you know, review if there's something that I go too fast on. Also, we'll be updating the documents as we need to. So, always kind of check in there. And I promise that if we make a change in our office, I will let Miss Drain know so that she can upload whatever it is or pass on the information because we really want to make sure that we're providing accurate information so that, it makes everybody's job easier. So bkdocs.us is where you upload all of your documents to the trustee. This is the website. And 13network.com. I don't know that a lot of you use it, especially you Phoenix folk. 13network.com is actually the website that we use in the office, like a broader version. But when I was practicing, this was my favorite thing because you can use the plan calculation tools that Dana uses in our office, and actually everyone uses in our office. I'm the least skilled at those. So if you have questions about those, I will be directing you to someone else. But I found it really useful to see like, this is when the last plan payment came in. This is how much has been paid into the plan. This is roughly the estimate of the payoff. And granted, you can't totally and completely rely on everything until you get it, like this is the payoff for the plan. But I could see when, checks weren't clearing, I could see how much I was going to get paid. So I highly recommend getting access to this website. I loved it and found it super useful. And it also showed exactly what what my client paid and when. Also, as you all know, ndc.org. I never really used ndc.org because I liked 13 Network so much better. So your clients need to use ndc.org to track their plan payments and their case. TFS Bill Pay, electronic platform for making Chapter 13 plan payments, which I'm sure you all know. And this one right here, this long one, it is the link for 341 meetings that does not require a password. And it is great. So and I don't know if you guys know this, there is a link for every single one of the trustees that does not require a password. You go to the UST's website, they don't change. They're not per meetings. It's just this is Dianne Kerns's 341 meeting link. And there's one for, Karchner, and for every single one, there's a whole list. But if you give your clients this link, then they don't need to input the meeting code or the meeting ID or any of that nonsense. And it takes them directly to the meeting of the creditors as though they had put in all that information. So it will make your life and your client's life a lot easier. So, communication with the trustee's office. Always send or copy your emails to mail@dcktrustee.com. I did not know this. I think Dianne had mentioned it to me before, and I either ignored it or I didn't hear it. It went in one ear and out the other. It is really important to do this because mail at dcktrustee.com is where everything gets logged. Everyone in the office can see it, and there's a record of when you reached out to us, what we said to you, and all of that good stuff. It will also make sure that your communication is not lost. If you're sending something to me and you need a signature and I don't happen to be in the office, and it's gone to mail at DCK trustee, it's going to get forwarded to who needs to see it. So that way you don't have to figure out who to send it to. When in doubt, mail at dcktrustee.com. Also, always copy mail at dcktrustee.com. And I double checked this with everyone in the office because I didn't want to say this and then have someone plot to kill me. But in fact, this is what you need to do. Um, Keep our office informed. Tell us what's going on before the last second. If you got a weird case or a weird situation, or something's going on, tell us. Please, please, please. We will grant you grace. We will help in any way that we can. And I'm going to quote my colleague, Dana Bunker, and she says, there is no such thing as too much information. So it's going to save us from reaching out because a lot of times, if you got something complicated going on in your case and we're just reading your schedules and your SOFA, we're like, what? I don't understand. And so we're going to reach out to you anyway. So just go ahead and let us know what's going on. Because it's helpful. And plus, you're not going to have your client quizzed about it at the meeting of the creditors because we're going to already know. We may ask about it, but we won't have a confused look on our face when we do. And please, 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 please answer our emails as soon as you can. And I'm going to say right now that I violated this because I would get the email from the Chapter 13 trustee's office and I'd be like, oh, caramba, I've got to do this. And I'm like, I'm not going to respond to them because I'm not really sure when I'm going to get it done, but I know I'm going to get it done tomorrow. And then before I knew it, a week had passed and and things happened. It it is so imperative that you talk to us. Like, just let us know. Just say, I am so sorry. I haven't got this done. Otherwise, we don't know what's going on. And we're not sitting around eating bonbons. And we do have deadlines that we have to keep, and we have audits that happen, and we have to keep cases moving. So please let us know what's going on, especially if there's something like if something bad happened and someone's out of your office, let us know. Or like, look, I'm gonna have to file to get an extension or how whatever's going on, please just respond to us. And when I first started, Craig had told me like no one responds to us. And then several other people in the office said no one responds to us. And I was like, no, they respond. You're just wrong. No, you really don't respond. So um please like make that your New Year's resolution early. All right, so here are some pre-filing tips. So some of you probably already do this. I did this. This was the greatest thing when I figured it out. If you don't get all your documents filed or signed prior to filing the case, sometimes you will never get your clients to sign documents. I would just do everything all at once because at the end of today, you're going to know everything that you need. And just don't file the case as an emergency unless it's a true emergency. Um, you definitely need to have 3 tax returns filed prior to the 341 meeting. Um, and I actually was on a hearing where I thought we were going to be talking about one thing, but the judge had different ideas and was very interested in why or if the tax return from 2021 had been filed one day prior to the meeting of the creditors. So, and basically said, we're not going to talk about anything else until we figure this out because I'm going to dismiss this case. And that was kind of a shock um to me that, like, oh, we're not okay, we're done. So you really want to look at that and make sure that your tax returns are filed. Um, And if they're not, because we have the situation in February or in March or even, right in April, that, tax returns haven't been filed for whatever reason, and that's legitimate. The deadline hasn't come, and so they haven't been filed. Ask to continue your 341 meeting, and we will do that for you so the tax returns can get filed and you don't get into trouble. Notice the IRS and Arizona Department of Revenue always, 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 always on Schedule E. You want to make sure that you're giving them notice, because if you don't, we're going to ask you to, and you're going to have to amend your schedules to do that. Um, Set up your clients on TFS bill pay when they're signing their docs. If you're virtual, you can do it online with share the screen or have them do it. um, set them up to make payments 7 to 10 days before they are due. And this is the biggest thing that I was starting to do before I stopped practicing in bankruptcy and went to this job was, if the payment was due on the 30th, I told my clients, you need to have that payment go out on the 20th. And we're going to talk a little bit more about that later, because I was tired of them being late. I was tired of delinquencies, but also, the it just is good practice, and best case they get done a little bit earlier because they've paid off their plan sooner. So again, get all necessary documents signed prior to filing the case, so there's no client chasing. And also, I don't know if it's someplace else in the slide, but I'm going to mention it. Tell your clients that they just cannot extend their tax returns. Like, they need to get them filed so that, while they're in the pendency of the Chapter 13 bankruptcy, they just need to, get their tax returns filed and get them to us within 14 days. Things will run much smoother. And, we're going to set up good habits. We'll start a fresh start. And sometimes there are issues why they can't be filed, but, I didn't get my documents to my CPA or my tax professional is not a good excuse. Not having, your W-2 or something of that nature, maybe. So, all right. So ID for 341 meetings of the creditors. We do not require attorney or debtor declarations about debtor ID. So remember that affidavit that we had to fill out, and when we were by phone, we don't require it anymore because Dianne is sitting there with the ID and she is comparing it to the faces on the screen, which is why we have to see the faces on the screen. The ID that you give us needs to be color. We have to have the color, no black and white. Um, PDFs of the government issued photo ID and social security card must be in color. Upload the photo ID and social security card on bkdocs.us under the 341 ID category. So make sure that you're doing it. Verify that it's been put there. We won't see it otherwise. And here's the other thing. I don't have access to everything in the office. So, and neither does anybody else. And that's security protocol. Like, I don't get to see, I couldn't tell you what the actual social security card number for any debtor is. I don't have access to that information, and neither does staff. And in fact, this information is purged after the 341 meeting because there's just too much liability for it. And we're not allowed to see it. But if you put it someplace else, you just gave it to us. So one, we're going to think that you didn't upload it, and two, you just spread your client's information, very sensitive, personal identifying information, to places it did not need to go. So make sure it's in the 341 ID category. Do not combine it with anything else. Make sure that it's, driver's license, social security card, 2 driver's licenses, 2 social security cards, or passport or whatever it is that you need to use for that information. But that's all that should go there. And you don't have to do any declaration about it because, again, the Chapter 13 trustee is going to look at it on screen and compare it. And then after that, the information is purged. So again, 341 ID category. All right, required docs for the trustee only You do not need to send these to the court. Some of them look like you're supposed to send them with the court, but if you look at the instructions at the bottom, it says don't send to the court. But you may already have templates where that's been taken out. So I'm telling you right now, what I'm asking for, even if it looks like it's a pleading, don't send it to the court. All right. You submit these documents to bkdocs.us. Do not submit all of them together. Submit them separately. Again, we all have access to to the documents that come in. Some, not the 341 information, but we can see the documents that come in. I'm not going to go hunting, for the, 2022 tax return or 2024 tax return. I'm going to look at the 2024 tax return category and see, oh, wait a minute, it wasn't filed. So if you put it someplace else or you put it with other documents, I may not see it. And we're going to bug you about it. And then you're going to be grouchy because you're like, I gave it to you. But if it's not in the right category, we're not going to know. And, you just need to send documents separately. So we need the trustee questionnaire, which I am going to, all of the documents that we're requesting, I'm going to send to Dianne Drain today, and she will be uploading them for the database. You can also go to the Chapter 13 trustees website that I gave you at the top of the hour, and get these documents as well. So we need last 2 years of tax returns redacted. The trustee questionnaire. Please, please, please. Domestic support information is what we need. We definitely need to know the recipient of child support or spousal maintenance. Please, please put that in the trustee questionnaire. It's on page 4, I believe. If you can't get that information or there's security issues or whatever, we're going to provide you an affidavit. It's on our website, that will, that you can tell us, what the issue is, and go from there. Also list on Schedule E. We have to provide notice to anybody that's subject to a domestic support order. So that will make it super helpful to us. You will get a gold star if you do that, because we don't see it all that often. 2 years of tax returns redacted. Only the last 4 numbers of the debtor's social security number. If you have a non-filing spouse or you have children, we do not want to know their names and we do not want to know their social security numbers. So please take that information out. And if your debtor's getting a refund, no bank account information, take it out. I know that a lot of you are super fancy and you can do Adobe PDF. For a long time, I didn't know how to redact on Adobe PDF. So you could always tell when it was tax return time because I had black marks all over my arms because I was crossing out all the information. And I apologize to my now colleagues for the very ugly redaction that I did, but I did do it. All right. We need the trustee authorization in all cases with secured debt. Err on the side of giving it to us. We use it to get information from car creditors, from, anybody that has a security interest in debtor property that we are paying. We have to contact those folks quite a bit, and we need that information. We also, Paulette will love you forever if you can get her the full account numbers for any of the secured debt that we are paying, because we only get the last 4 of, the account number. And so when you call in, it's like, oh, well, what's the last 4? Well, it's 1, 2, 3, 4. Well, we have 2,000 accounts that look like that. So trustee authorization in all cases with secured debt. If you have a case, give us the mortgage creditor checklist. Any case where there's a mortgage, whether you are a conduit or not, please provide us that information. We do have on our welcome letter and also the trustee questionnaire, bank account information and other income information that we would like for verification. Also, if you need a translator, please let us know. It's not a problem to have a translator, but we need to go ahead and know about that so we can prepare. All right. Um, Document submission, as I said, BK Docs. Do not email us documents unless you are specifically asked. So there may come a time where I'm like, I need to see this. Just send it to me. Or, a case administrator might do that, or Dana might do that when you're working on your proposed SOC. Go ahead and send it, but only if asked. And again, copy it to mail@dcktrustee.com. Don't lump a bunch of documents together. Um, Again, they need to be individual. Please use the appropriate entry for submission. Otherwise, we will not find it. This is the first time I'm doing this presentation, so apparently these things were very important to me and were listed twice in the book. So if I am being um, if I'm repeating myself, it's because I have not done this presentation before. So it's new. All right. We accept electronic signatures on all documents. We also accept declarations in lieu of affidavits. So most certainly the Chapter 13 trustee, Dianne Kerns, is going to say in the meeting of the creditors, if it's a business case, I need an affidavit of no trade debt. You can go ahead and do a declaration, but it's our lingo, right? Do an affidavit on taxes. If your client doesn't have to pay taxes, do an affidavit for this. We will accept declarations. The federal the federal rules allow for that. You just have to have specific penalty, this declaration is made upon penalty of perjury. If you need the specific language, let me know. Our documents that are on our website still are, quote, affidavits that require a notary signature. But if you mutate them into a declaration, that will work as well. And at some point, we'll get around to doing that on our website. Maybe in the new year, I'll take that on as a project and I will send it to you when it's done. What you want to keep in your files about electronic signatures and proving that your client signed it, that's up to you, but we accept electronic and also declarations. So you don't need to mail us pleadings. Electronic service is fine. I get this email every day that shows me every single thing that was filed in a Chapter 13 case, which is very daunting. And so I know if you work on Sunday, like the emails I get on Monday are my favorite because they're smaller. So I definitely know who's been working, because it's everything that was filed the day before. So we get electronic service. You do not need to mail us anything. You can just, go ahead and save your postage. All right. Tips on business cases and non-filing spouse cases. We consider any case where a debtor is self-employed to be a business case. You need to file monthly operating reports, also called, what are they called? They're called something else on our website. Um, Monthly operating reports. When I send this to Dianne, I put both terms on it. You must also submit a business questionnaire and an affidavit of no trade debt. The affidavit, like I just said a minute ago, can be a declaration. On Form 122C1 and 2, both of them should be done for any business owner. They should be filed, and gross income should be used, and then expenses are deducted on line 43 because of the In re Wigand case. It does not allow expenses to be deducted elsewhere. So on non-filing spouses, community property assets and income should be included in the schedules if you've got a case with a non-filing spouse, and also Form 122. Pay attention to line 13 for the marital deduction on 122C1. Essentially, you're kind of going to treat the case as though the non-filing spouse is filing, just you will not use the spouse's name. And if you have issues with that, please just contact us and we'll talk you through it. All right, 341 meeting.
Lisa, let me,
Yes.
we've got a couple questions back a wee bit. Scott is wanting to know if sorry, what bank statements do you normally ask for?
So we haven't really been enforcing that, but it came to our attention that it's on our documents. And so I think it's 3 months. You're gonna have to look at it. We just decided that we were gonna start doing it, so we would like to see the bank statements
Okay.
that are
And
listed in the questionnaire.
then Andrew wants to know, do you consider a 1099 worker to be self-employed?
It depends on what they're doing. I mean, are they 1099 from their themselves, or how is it working? I mean, generally what happens is um at the meeting of the creditors, Diane will ask, information about the business and may or may not want monthly operating statements. Sometimes she does, and sometimes she doesn't. I think real estate agents are 1099 contractors, and so that's not, we might want that or might not. I think it's a case by case basis. If you have a question about a particular client or situation, just reach out and we can talk about it. But generally I never personally um I had my client do the business questionnaire. They were aware of the business questionnaire and that we were going to have to file monthly operating reports, maybe. And so I would have them be giving me that information, but I wasn't necessarily submitting it until after the meeting of the creditors when the Chapter 13 trustee said, no, I really do want this, or no, I don't. So generally you will know at that time, but you could reach out to us ahead of time.
Lisa,
Yes.
if I might interject, a debtor engaged in business is defined in section 1304, and it's someone who's self-employed and incurs trade debt. So technically, if you're just being 1099 and you're not operating a business and incurring trade debt, you're not a business debtor.
Thank you. See, learning curve like this. Maybe.
For those that don't recognize voices, that was the boss, Dianne Kerns.
That was my boss, the Chapter 13 trustee. All right. So, please prepare your clients and yourselves for 341s. It is a huge problem. Anybody who's been on any meeting of the creditors has seen the people that are prepared, and it wastes everyone's time. So we're going to start pushing them to the end of the calendar. If there's tech problems, or I can't make my camera work, or the sound isn't working, or we're just going to move it to the end of the calendar and figure out, and you guys can work it out, and then we'll take it. You got to treat this like any hearing. You got to prepare for it. So practice with your clients before the 341. I send around an email to everyone with practice links. You can practice with our link, except for on the day of the meeting of the creditors. There, when you are using a computer, I don't know about a phone. If you use the link that I gave you that doesn't require a password, and you click on that, it's going to bring it up, and you can check your audio and your picture before you get on, and then you can, make sure that it's off before you enter the meeting of the creditors. So you can have your clients in your office with you. We don't care if they're in their car. Tell them not to dance. Well, actually, they should have their camera off and their sound off, because there was one where they were in their car and they were having a little dance off. They just need to be in a quiet location. So definitely tell them, like, keep the camera off and the sound off, because you've all seen the ones that are sitting there terrified and they're the only one on by themselves. We're even going to be letting the debtors representing themselves know this as well with an email, so that we can have a very clean record for the meetings of the creditors. Test it ahead of time, please, please, please. Also, if you can, it would be great. And the UST has even put out, they have 4 different they have links for practicing, and they have information on, if you have a Spanish speaker, how to change the language. They also, I believe, have information on how to change the name, but YouTube is a great place. So change your name so your name is either your firm or your name. And your client isn't Skater Chick or, Snowflake or, Fluffy the Magic Dragon. Like, make sure or just a number so we know who it is, because we are actively allowing people in to the meeting, and they can't, we need to know that they need to be there, and and it's not inappropriate. Also check and see if your clients join the meeting. You have the ability to do that. Like right now, you can go and check all the participants in this meeting. You can do that in the meeting of the creditors as well. Make sure your client's there. And if they're not, find them before we call the hearing. Also, if you have something come up and I'm on the meeting, I'm a participant on the meeting, and you're stuck someplace else and you need to have your staff let us know that you're coming, but you're in another courtroom or any of that, like email me or email Alicia. Alicia's at mail@dcktrustee.com, and we'll get a message to the trustee so she knows, because stuff happens. Just reach out to us and we'll make sure that it's okay. All right, I can't even speak today. It's Friday. All right, tips on Chapter 13 plans. So some of this is, again, stuff you might want to know, but that you already do. Build in a cushion for payment of unknown charges for post-petition mortgage expenses and fees, and even your own fees. Like, I see a lot of cases where it's zero to general unsecureds. So what does that mean? Every single time you want to get paid more, even if you're on a no look, because how many cases skate through and there's no work you do after confirmation? It is, in my experience, incredibly rare. So, if you've already built in something for the general unsecured creditors and you're not going to mess up, you're not going to violate your liquidation analysis and you're not going to violate the 1325 analysis, then you have money to go ahead and pay yourself, or also, go ahead and pay the post-petition mortgage expense. Because what's going to come in if there's a mortgage. So I would always build in something. We're not going to require it. It's just something that I see come up quite a bit. Put in language in non-standard provisions about tax refund turnover and payment of post-petition notices of post-petition fees that are going to rise in the future. And I don't know, I'm going to provide a sample SOC for Dianne to post. If you want the language I'm talking about, reach out to me, because I don't know if it's anywhere in any of the materials that I'm going to submit. But if you don't know what I'm talking about, reach out and I'll get that to you. So build in 10% trustee fee, 10% of all plan payments. You multiply that by point, so decimal, and 6 ones. Now, I am not a mathematician. This is kind of like, you got to take it on faith. This is how you do it. But if you come to our seminar on January 9th, you're going to understand why. Everyone always gets grouchy about the 10% trustee fee. But here's the thing, the trustee fees vary throughout the duration of your plan, right? So sometimes it can be lower and sometimes it can be higher. If it goes higher while you're in your plan, then you potentially, at the end of the day, could have an underfunding problem. It could go lower. That just means that there's more for the general unsecureds. And, it is what it is. Like, if you don't want to be going to your client and saying, hey, we're going to have to raise our plan payment because I built in a 4% fee because at the time I filed, that's what it was, and now it's higher. Just go ahead and build in a cushion. All right. If you're using the model plan from the trustee's website, take out the instructions on the document. Don't leave in, parentheses, insert creditor name. Take it out. That will make it a cleaner record. Also, deal with all secured debts. Even if we're not paying them, the trustee's office is not paying them, um, just tell us what's being done with them. They're going to be paid directly outside, and give us some information in non-standard provisions. You see this a lot with the HUD loans that are kind of like in the background unless you sell the house and then it comes back. Or like in year 3000, they might ask you for a payment. Just go ahead and say that it exists and that, it's not due, there's no payments, it'll be dealt with outside. Give us that information. After filing the case, file a request for the Chapter 13 trustee to begin adequate protection payments. I miss putting in protection there. So adequate protection payments to the creditor. File it under the notice of filing entry on the court docket. So notice of filing request for the Chapter 13 trustee to begin adequate protection payments to the creditor. Now, creditors are allowed to file these requests. And in fact, I believe Howard is on the line and he does it routinely, but no one else does. So go ahead and get it on file because we can't start sending payments to the creditor until we have been told to do so by this notice. This is going to save your client money. I didn't put this together, but think about it. If the creditor starts getting money as adequate protection, it's going to lower the interest rates, right? Or the amount of interest that's being paid, not the rate, the amount of interest that's being paid. So I am going to give you one of these, and this does get filed with the court. You can use one request for multiple secured creditors. So if your clients have 2 cars, you can do one, you don't have to do 2. And so, as I said, creditors rarely do this. It's almost a standard clause in all of the objection evaluations that I do, because they're just not being done. So just go ahead and do it out the gate. All right. Amending or modifying Chapter 13 plans. So if you are changing treatment of a creditor negatively, either in time or amount, you need to amend or modify your plan. Excuse me. There's no need to amend if you're just increasing the plan payments. Like your liquidation analysis is off, you're underfunded or whatever, and you're going to raise the amount, from $100 to $150 or however that works. You don't need to amend to do that. You can fix that in your proposed SOC. You must amend the plan if you're surrendering property. You must amend the plan if you're lowering the amount to general unsecured creditors. If you need to amend or modify your plan, do it as soon as possible so you can start the clock on getting it confirmed. And if you're unsure about whether or not, you need to do a plan amendment or a modification, reach out to us and we'll help you. Because here's the thing, we all want to get these cases confirmed for a lot of reasons. I liked getting paid and I liked having it off of my desk. But the other thing is, the longer I waited to do something, the more my clients would change their world. Like, the more likelihood that there was going to be a car accident. In fact, I had one where there were 2 car accidents. Before I even got the first one dealt with, they had another car accident. Knock on wood. I don't want Chapter 13 debtors to be in car accidents, but the longer, lose the job, other things happen. So just let's move these along, so we can get cases confirmed. All right, plan payments. Plan payments must begin 30 days after the date of filing the bankruptcy case. Electronic payment is our preferred method of receiving payment. And because otherwise they've got to do a cashier's check or a money order and have it sent to our PO box in Memphis, Tennessee, and the mail is slow, et cetera, et cetera. So if they can use TFS bill pay, that's also good for you because you can verify that the payment has been made or it's in process. So have them make the payment 7 to 10 days prior to the payment due date. and the client will never be late. The payment is not made until it arrives at our office. All payments are posted within 1 business day of their arrival. So just because your client is like, the money's out of my account, it's through TFS, and TFS shows that it's processing, we do not get guaranteed funds for at least 7 days. So it does, I mean, that's great. I'm glad that they're doing that, but that doesn't help when your client has a delinquency. So if you can just get them started doing it sooner, they're going to be done a little bit earlier, and you're not going to have the headaches that you have when your clients get delinquent and they're like, oh no, right? Also have them use auto pay. They can pay multiple times during the month on a payday. They can also use e-wage, where they direct their employer to send the payment. And it's completely confidential. The employer doesn't know it's coming to the Chapter 13 trustee. They just say, I want some of my money sent here. MoneyGram is the best way to cure a delinquency. It's 3 days for us to get the money, but it's guaranteed funds, so we can rely on a MoneyGram for reinstatement if there's a problem because of delinquency. Again, we're not going to, if you send us the bank statement or, a screenshot like, oh no, the money's out of the account. It's 7 days before we get it. So, plan ahead. Monitor your client's payments and jump on the delinquencies, especially when you receive our objection evaluation, because we are supposed to not confirm cases if they are delinquent. So a lot of times it takes us about 45 days to review and get the case confirmed, so your client has time to play catch up. All right, objection evaluations. So it should be sent to you within 40 days from the conclusion of the meeting of the 341 meeting, or 56 days from the filing of an amended or modified plan. I never knew this in the years that I practiced in bankruptcy, but we send them on Thursdays. We file on Thursdays. I always figured that the Chapter 13 trustee's office filed the objection evaluations when I was unavailable and my clients were going to freak out and blow up my phone. That's when I thought they got filed. But apparently that coincides, my schedule, and that coincides with Thursdays. So one of the things that I have to do in my job is by Thursday at noon, I have to have reviewed all of my objection evaluations. And it kind of freaks me out because I'm worried I'm going to forget one day. Like, I think I might wake up on Thanksgiving and be like, oh no, okay, wait, we're not doing it this week. So, but it's always Thursday, and it should be sent 42 days from the conclusion of the meeting of the creditors. All right. Once you get that, a stipulated order or a proposed stipulated order confirming the Chapter 13 plan must be submitted to us within 30 days of the date of the objection evaluation, or the case could be dismissed. Now, I was not particularly good at this, especially early on in my career, because I was like, oh, I have 30 days. I don't have to deal with this right now. I have more pressing matters. If I were to do it all over again, and I had started doing this, later on in the last year, I would look at it and be like, oh, I did that. I've already done this. Okay, cool. That's easy. Oh, I just need to amend this one thing. Great. Out the door. And so I would knock out the low-hanging fruit. I even did my motions to waive the conduit plan as soon as the proof of claims came out, because I knew I was going to get it. And so if it happened to be in my objection evaluation, it was just an oversight, or it crossed in the night. So don't get grouchy if you've already gotten the order and we have it in the objection evaluation. We just missed it, and it's one less thing you need to do. So be like, yes, done. So, try to get as much stuff ready So you're not scrambling at the last second. You're not like, oh my goodness, it's day 31. I haven't even looked at this carefully. So I would really look at it ahead of time. And if you've got to amend your plan or you think you might need to amend your plan based on the objection evaluation, do it immediately to start the time. And so that we can, get the case confirmed. All right, so your proposed stipulated order confirming Chapter 13 plans. Again, I'm giving you the things that I've seen, so this is not, a deep dive into SOCs. When we give you specific language in the objection evaluation, please use it. Like we wrote it for you, go ahead and use it. You can make some changes, but that language is going to work. So why do something that may or may not work? Don't add confusion into the mix. So also do not put in a specific number amount for conduit payments or total conduit payments or the amount you're going to pay to general unsecured creditors or for anything that is not based on a proof of claim, because you're going to be wrong, period. You're never going to get it right. We all joke that we went to law school because we can't do math. We're never going to get this right because the escrow amount of a mortgage changes, all the time. Everything resets. You don't know if you're going to ultimately have to do something else. Just, you don't need to have the actual numbers. Don't put them in there. Conduit's going to run from month 1 to month 60. Great. You don't need to say this amount is going to be paid because you're going to be wrong. Because you just don't know what's going to happen in the future. So don't stress out about the math on that. Please file your fee application simultaneously with your SOC submission. If you do that, and I learned this from a colleague of mine, and if he's on, thank you for that. You'll get your fee application approved in the time it takes for us to review your SOC. So you can go ahead and put in the amount that you're requesting, file your fee application. So all of your time for your fee application, everything is in, and it's in the SOC. You file the fee application, you'll get your order 21 days out. We're going to hopefully get your case confirmed within 45. So that works perfectly. And you can reach out to Dana and she can put in the docket number of your order. Address everything in the objection evaluation. Like don't think that we won't notice. Go ahead and just deal with it. Or if it's not something that needs to be dealt with, explain it to us in the trustee letter. Attach a plan summary to the SOC. And I am going to send Dianne Drain to post. It's a sample SOC. And so, feel free to use that. There is a plan summary attached to it. And you can also find it on our website. It is 14 days for the turnover of tax refunds. Please update your templates. We get this over. It's amazing. It's not 30 days, it's 14 days. Please change your templates. Because I know you guys are probably like I am, and even the trustee's office, we don't even see the documents anymore. It's like, yeah, that's tax stuff. Yeah, that's, So really take time, when you stop eating bonbons and running your busy practice, look over your templates, like actually read them and go, oh, wait, we have this 30 days in here, and change it to 14. If you are getting the same comments from us over and over on your SOCs, please change your templates. Or if it's something that you think that you're doing correctly and we're still calling you out on it, reach out, let's fix it, let's figure out what's going on. But if you're getting the same thing like the 14 days that I just said, please change your templates. We shouldn't have a template for sending back your SOC. Like, we don't want to return SOCs. Please, make sure that your templates are up to date. If you're not going to be able to meet a deadline for the SOC, please obtain a court order extending the time to submit the SOC. We get audited, we get looked at every year. We have to prove that we're moving cases along. We would like there to be a clean record on the docket. So if the judge says you can have 60 days, that's fantastic. And also it's not a motion to extend. The local rule actually says it's an objection to our objection evaluation or the trustee's recommendation. And in fact, you have to set a hearing for that. Right now, the judges are signing off on motions to extend. So that's really something with the bench. But get get an order from the court so that we don't have to file a motion to dismiss or any of that stuff. Sometimes we can give you like a few days if something's coming up, but if you're going to need a significant amount of time, you definitely need to get that order from the court and ask for the time you need. You know, like, don't say I just need 2 weeks when you know for a fact you're gonna need at least a month or you're gonna need 60 days. And if you have a legitimate reason why you need an extension, well, put it in your request to get that extension and you will. But I've seen, in fact, I had several in the last 2 weeks where they all asked for an extension to the end of July and then nothing happened. Like it wasn't, we never got anything. It was like crickets chirping. So, ask for the time that you need so you're not doing repeated requests for extensions. Also, if you want more information on SOCs, our guru and my predecessor did a seminar in 2024 for ACBC on SOCs. So I put in the link here. I think it's a hyperlink. I don't know. Cut and paste it or go to YouTube and get it. And if you have specific questions, I will walk through getting your case confirmed and the stipulated order confirming. And if I don't know the answer, I will find it for you. So please reach out, but don't do it when you're on day 35. Like, try to do it sooner rather than later. All right, submitting the proposed SOC. You have to file a notice of submission of proposed stipulated order confirming Chapter 13 plan on the court docket. And you should not, there is a specific entry on ECF for this. And I think everyone just stops at notice of submitting. You got to just keep on going a little bit further. And I know this because I learned it the hard way because I did notice of submitting for years. And then I saw someone else smarter than me. And I was like, where was that? And, oh, it's down below. I just stopped because it fit. There is actually a notice of submission. So use that. Submit the requested documents with the proposed SOC. Use BK Docs. Do not lump everything together. We don't want, you might have a package in your office. We don't want it. We need it broken up and in the appropriate place. And so you can put it in, the section of BK Docs that's talking about stipulated order confirming plan, but you put it in as separate docs and then title them for us. And submit with the trustee enclosure letter. I'm going to give you a sample. Detail how you fix the issues raised in the objection evaluation. Make it really easy for us to understand. It's going to make the confirmation of your plan faster. And in fact, the one I'm going to give you, and I never did this, and so I apologize to the Chapter 13 trustee's office. Go in and put what the objection evaluation said, and then under it put, this is what we did to fix that. Because then it's really easy. So I can just go in and I can look at your enclosure letter and be like, oh, that's cool. Check, check, check. And I don't have to pull up the objection evaluation and your letter and compare. And if for some reason you need the language that's in your objection evaluation, reach out and I'm happy to send that to you. All right. Did I cover everything? Yes. Okay. The applications. If you are not getting payments from us by ACH, I'm going to submit a form so you can get electronic payments. They will go out when we disperse every month. It's a really good way to get paid by us. You don't have to worry about the mail. Fee applications. Please do your fee applications. That would be great. Your first fee application when you request to have your case confirmed would be awesome. You should also get an order allowing payment of administrative expenses if you have a no-look flat fee. And if you want to know how to do that, or you want the form that I used when I was practicing, please let me know. I'm happy to send that to you. But you can link it back to your plan. So, 14 days after your 341 meeting, you can do a notice of lodging proposed order. It's an order allowing payment of administrative expenses. If you got paid $2,000 and you're going to get another $2,500, that's what your order says. You get that, you're off to the races. That way, if your case, gets dismissed or there's a conversion, we get discharged as the trustee, and we got to give money back to the debtor. And if you're owed fees, we need to not be waiting for your fee order. So if you have a fee order, it protects you. Plus, it's cleaner for confirmation. We need to be able to see if your plan is underfunded, and we can't just, what was it Ron Allen said, Sherry Lewis with the crystal ball? Like, we can't just, guess like this is what your fee application is going to say. It takes you at least 21 days negative notice to do it. So go ahead and get that done. And if you need additional fees, so long as you're not messing up the liquidation analysis or the 122 CMI calculation, then there's no problem giving you additional fees without amending or without modifying the plan. All right, motions to dismiss and notices of intent to dismiss, and return of SOCs. Make sure you don't miss the deadline to resolve MTD or a notice of intent, or a return of the SOC. Like, just don't. I get it. I got them too. I would get motions to dismiss. The ones that were my fault, I was like, oh, yeah, I was supposed to do that. The ones that shocked me, or I wasn't totally shocked, was the motions to dismiss for failure to make plan payments, for plan payment delinquency. I mean, I generally knew who my worst offenders were, but I was like, really? But when I got those, I made sure that it got resolved, and I started dealing with it right then. And that's really what you need to do. Triple check, dock it 4 times, highlight, make sure that you meet that deadline. Or get a court order, like do whatever you need to do, get a court order extending the deadline for you to comply. Because if we upload the order to dismiss, we're not going to pull it back. You're just going to have to do a motion to withdraw the dismissal order and reinstate the case. Because there's no, it isn't a secret. It's not 2 days. At minimum, it's 14 days. So if the order has already been uploaded, don't reach out and ask for us to take it back. You're going to have to do a motion to withdraw the dismissal order and reinstate the case. In the past, we had gotten queries, and sometimes we could do it or not. It's colossal hassle. Just don't let the order get uploaded. And then you're fine. And if not, then you're just going to have to file a motion to withdraw the dismissal order and reinstate the case pursuant to the local rule. If Dana, who handles the final, there's a lot of people that touch your proposed SOC. I had no idea how many people like audit the numbers, look at it, all of that. But Dana's kind of at the end where she's putting it all together. If she asks you to change your SOC so she can swap it out, do that. Because if you don't do it and she returns the SOC on the docket, you have to submit all your confirmation documents again. And you have to resubmit the SOC on the docket again. And you have to send us another enclosure letter. It seems silly, but that's the way it works. So just if she says, hey, you need to make X, Y, or Z change, make the change, then we don't have to return it, and your case gets confirmed faster. If we do return it, make sure you docket that deadline and get it back to us sooner. All right, motions to incur debt and letters for permission to incur debt. Read local rule 2084-25 and comply with it. Send us the last two pay stubs, which is required by the rule. Give us an estimate of the amount of loan, monthly payment, and interest rate. Like, it's hard to actually get a contract, for a car and then get permission and still have that car available. So you can kind of just give us the estimated amount. Send us your adjusted Schedule J with the new payment, which if you do get permission, you're going to have to file with the court. I always went a little bit higher than what my client needed. Like we wanted to spend $300 a month, like no higher than $300. I would go $350 if I could do it with the budget, just because I didn't want to have to send repeated letters, which is, I learned the hard way, and I don't know if my boss remembers this, but the first one I did it spot on. And then lo and behold, when my client went and got the loan for the car, they were like, oh, well, you actually need it's $25 more. And I had to go get another letter from the Chapter 13 trustee, and I was pretty embarrassed by it. Pre-confirmation, we will sign off on an order for you to make it easier so you can, file your motion and know that there's trustee approval. You're still going to have to do negative notice. Post confirmation, if you write a letter on your letterhead with all the elements of the local rule, and the trustee will sign off. We'll sign off on it. Put in a signature block, just like you would on an order that we're approving, like approved as to form and substance, form and content. We will do that. Post confirmation, incurring new debt or selling property, it's kind of all the same thing. Follow local rule 2084-25. All right. Motions to waive conduit payments. So we require a court order if there's any arrearage on the proof of claim from the mortgage company on the first mortgage. We'll sign off on the motion if the arrearage is through no fault of the debtor, so like projected escrow shortage. Put a signature block on the order for the trustee to approve, and we're happy to do that. You can send, again, mail at DCK, but you can also copy me on it, or Dianne. If we won't sign off on it, then you just have to file a motion and have the court sign off on it, and we will accept that. Again, I would do it as soon as you got the proof of claim if you know it's going to be an issue. All right, so here we are almost to the end, so you'd have to listen to me anymore on this Friday. So here are some other random notes. If your client is in a car accident and you're going to surrender the vehicle, let us know. We'll stop making any further payments to the car creditor so you can get an amended or modified plan on file if you're going to surrender the vehicle. If you're going to dismiss the case, let us know and just do it. Or if you're going to convert it, so that we don't have to meet all the deadlines we have to meet and spend a lot of time on a case that just is a no-go. A lot of times there is no actual reason why you cannot dismiss the Chapter 13 case without any prejudice to your client. I think there are a couple myths going on about it because we have a lot of times people say, well, no, it'll be bad. If we dismiss it, we're waiting for you to dismiss it. Well, one, let us know, but two, there really isn't, if you think that there's something negative that will happen to your client, go and find the rule, because I think that someone somewhere passed around that it's better for the trustee to dismiss this case idea, and none of us really know where that is. So if someone can find it and put it in the chat, happy to be shown to be wrong, but I think that it was a myth. So underfunding issues are generally because priority and secured proof of claims came in higher than what you originally scheduled. Rerun the numbers with the new amount, and that likely will solve a lot of your underfunding problems. Also, you can, you know, look at Plan Calc on the website that I was showing you on 13 Network. And Dana will help you with that, as it is not my super good skill set. Please round your plan payments up. Don't use dollars and cents. I've seen a couple where it was like $532.17. Just make it $533. My clients, even when I made it $533, always came up with their own amount. Just round it. It's going to be easier for everyone. If your Form 122C1 and 2 is negative, put in 0 on the 1325 analysis. Don't have negative numbers. I'm also going to say this, and I thought I had put it up higher in the presentation and I could have blown past it. We would really like everyone to do Form 122C1 and 2. That would be great. Because it helps us. We calculate plan payments, or at least CMI, based on the means test, or Form 122C1 and 2. Even if you got a below median debtor, if you could go ahead and do the full amount, you're going to save a lot of problems with us and funding. So if you could please just go ahead and, if it's a case that's coming our way, just go ahead and do it. Generally, it's better for your clients, and it's going to save you time in the long run. If you've got an over median debtor, they're over median. And it's got, even if you, after doing the means test, you get them under, you get them negative by $1 million. There's still an over median debtor. You still have to propose a 60-month plan. 100% plans are not 100% until all the plan payments have been made. I learned that one the hard way when I told my client that they could keep their tax refund because they were 100% confirmed plan. And I was told that was not true. And so I had to deal with my grouchy client. So, and it makes sense. It is what it is, and things change, but it'll shorten the length of the plan if you're turning over your tax refunds. So it's not the ultimate, you know, excuse for everything. Like, oh, well, this is 100% plan. This is 100% plan. So here's some other random notes. We disperse payments to creditors and you on the first business day of the month. When you amend or modify a plan, review the objection evaluation or previous SOC so you have the most up-to-date treatment of the debts and pay schedules. And I violated this again, apologize to my new colleagues in my office. I would forget to do that. And so a lot of times I'd be working off of I would forget that in my SOC or in the objection evaluation, there was something that I monkeyed with, like, oh, I raised the plan payment for this, or I did this, or they wanted me to do this, and oh, I could fix this in my amended plan or my modified plan. Go back and look at those things, because if you deal with your objection, all the things that were in the first objection evaluation, when you amend your plan, the next one's going to be super easy. And by the way, those are my favorite objection evals, is the amended or modified plans, because most of the stuff has already been dealt with. You can also deal with the amounts that have been paid, as I've indicated below. So we need to have what's actually been paid into the plan, but you can do it as a total, whatever the amount is, total paid through months 1 through 36. And then on a go forward in your modified plan, you can say this is the amount going forward. So month 37 through 60. And that works for amended plans as well. So here are my final notes. Please don't blow smoke at us. If you need an extension, that's cool, but give us a specific reason. Be real about the time that you need for the extension. Ask for that. Let us know what's going on. This sounds crazy, and I still make typos. And so if you get one of my objection evaluations, I hope that there's no typos, because I try really hard, but it happens. But I have seen some of these some plans and SOCs that have come in, and no kidding, like 10 typos. So please, please, please look at them. There shouldn't be like 15 digits in your plan payment. I had one that was like decimal 5 digits afterwards. Like, please just look it over, read it. Um, our office is not your adversary. Um, we want to confirm cases just like you do. We have to look at certain things. You know, we have to abide by certain rules, guidelines. We get audited a lot. And, you know, we want to help you be successful because it helps us be successful too. So please reach out. We want to get these cases confirmed. And, we don't get paid if the cases don't confirm. And, so we want to confirm them just like you do. But I also, don't want people not to get paid themselves because they're, like I feel scared to contact the trustee's office and I don't know what to do. And consequently, nothing's been done. Please reach out to me. I promise I will not bite you. Um, if there's something we can do to assist, the trustee has discretion in some matters. And there are some cases where, you just need a little discretion. It's a special case. So, please reach out, let us know. And here's the other thing. We can't confirm your case if we have nothing to confirm. A lot of times people will complain like it takes so long to confirm a case. And granted, it does take a period of time to confirm a case, but we can't do anything if we don't have a proposed SOC or the documents that we need. So please, if you can, try to get us things as quickly as possible. All right. Phew. Anything else? Any questions?
I do have a couple of notes that folks have suggested back when you were doing the kind of the guaranteed payment from the client out of wages, et cetera. Scott Greaves is reminding us that we can get a wage order from the court. So that's certainly.
Yeah. And so a wage order is a way to deal with it, but sometimes I think it would depend also on the employer.
Mhm.
If it's the federal government, sometimes that can be a challenge. But if you got a client that's consistently not paying, then sometimes you got to do it. Um, or maybe even like the possibility of like your employer might know because there's going to be a wage order from the court. Maybe that'll get them in
Yeah,
line.
line.
But yeah, I mean, like we're fine with a wage order. But just think about it if it's a um, federal employee.
Now, Nick is commenting on as far as don't put the specific dollar amounts in. He says, doesn't the plan summary attached to the SOC have specific numbers, say the distribution to unsecureds?
Yeah, I mean, you're saying at this point in time, but your SOC, like whenever you put in the numbers, I mean, you can if you want to, but they better be right. And I don't know how you can always have them be right. And why would you want to? Like, I'm telling you, you don't have to do math for the body of your SOC. You're saying 1 through 60, there's going to be a conduit payment, right? And if the mortgage goes up from 1,500 to 1,600, you don't have to make any changes because that's going to mess with your total. And it's also if you're like the mortgage payment of X dollars is going to be paid, you know, for 60 months, well, that's incorrect. Like we're going to flag that. So,
Okay. And when you were talking about motions to dismiss and there being some restriction on the debtor filing the motion or getting the order versus a trustee, Ken makes a note here to make sure on a motion that we file that we note that the dismissal is under section 1307B. Ken, if you want to expand on that, please unmute yourself. We can't hear you. Okay, let's move on. Tammy.
How about now, Diane?
Oh,
Can you hear
there
me now?
you go. Got it.
Okay.
Go for it.
Yeah, I moved to dismiss a few years ago and didn't specify the section, and Judge Wansley denied it, despite the In re Nichols, and the debtor hired another attorney to take it on appeal and actually lost on appeal, saying that the judge doesn't have to dismiss it if it doesn't specify that it's under 1307B. So just be really specific about that.
Good point. Tammy Johnson is asking, sometimes debtors who need a 7 but aren't eligible yet file a 13 and can't afford an attorney. Can you speak to how pro se debtors can navigate your office? That's a huge question.
That's a huge question, and we don't have time for that today.
Okay.
Happy to chat with you, Tammy.
All right. Carlene goes on and says, thank you very much. Will you be giving us an adequate protection form through Dianne? The trustee's authorization raised secured claims is filed with the ECF, correct?
And she corrected herself. Nothing
Oh,
is
never
filed
mind.
on
No one
ECF
says not to file. Okay, you're right.
except
Right.
for your request to begin adequate protection. And yes, I have one of those forms, and it's also on the website.
Okay, and we'll be
But it's called something. We're going to change how it's on the website. It's called something funky. Just look for AP.
something funky, huh?
Something.
And I was going to invite Dianne Kerns if you want to add anything here or say hi.
Thanks, Diane. I was just going to say the adequate protection form is on our website. It's under the heading for creditors, and it's called AP commencement notice. So it's right there. I just want to say thank you to Lisa for putting this together. She's been a great staff attorney, and I really appreciate her proactiveness and sharing this with everyone. And I hope that if you have any questions, feel free to email, pick up the phone, whatever. Lisa and I and my entire team are here. We're happy to collaborate. You know, sometimes we'll have disagreements on how things turn out, but we want to work with you because we have the same goal. We want to get these cases confirmed, and we want to get these people the fresh start. We may have differences on what the amount of dollars that are required to do that, but talk with us, and we'll always see if we can find a solution.
Anyone else have questions?
Well, I thank you.
Well, thank you.
Please come. So Dana's, if you want to dive deeper on SOCs, Dana's seminar that she kind of led from March of 2024, I gave you the link, but you can also get it on the ACBC website. And definitely, if you guys are interested in the 10% that I mentioned and how trustees calculate their percentage fees, come January. We've already got the presentation together. We're going to have Carrie Ebert with us, and Dianne will be on. I just have to be the moderator on that one. And I think it will blow you away. And I am so grateful that I get to work with such a great group of people. I do miss the ACBC listserv. I do in a big way.
So much.
But I love you guys. Thank you for letting me speak, and we'll get back on next year. And you know, if there's anything that changes. So
now, on another note, on December 10th, over the lunch hour, ACBC is sponsoring about a 1-hour presentation on the new General Order 25-2 for those who have not seen it. And if you do any Chapter 7 at all, whether you're commercial or individual, go read it. But what will be happening there is Crystal Ahart will be going through some practical tips and some suggestions as to how to deal with that in your own forms and all. Judge Winery will start off the program talking a wee bit about the why and why this is important. So your announcements already went out while we were sitting here on this program. So sign up for that if you do any Chapter 7. And this one is open to the entire world, your whole office, your clerks, whatever it is. That's important enough that everybody understand. It becomes effective in January for every single 7, converted or original. So show up for that. Lisa, as always, my heavens, I'm going to have to go back and actually listen to this recording again in order to get it all in my little old brain. And for all of you, it will be at our ACBC YouTube channel. It will also be over on the ACBC website. Whether you're a member or a non-member, it doesn't matter. We're going to post in every place we can think of as far as this program. So last up, opportunity for anybody who wants to ask Lisa a question.
If I owe you email from the last couple days, it's because I was working on this.
Yeah,
So sorry. I will get back to you, I promise.
Okay. Well, it looks like congratulations from Crystal and
Thank you,
etc. So
everybody have a great Thanksgiving.
Oh, you too. Oh, where are the materials, Stuart? I've been posting them periodically throughout the program, but you're also welcome to contact me at admin@acbcforum.org or go to our website and get the materials there.
Yeah, and I will send all of the forms that I mentioned so that you can post them on the ACBC website, but most of them are from the Chapter 13 Trustees website.
Okay, and Crystal reminds you, get your cert before leaving. I will post it again in case you did not get it earlier. And for those of, I post the materials periodically throughout the program. The reason for that is we're not changing the materials. It's that the new people who have signed on don't see anything that was there before they signed on. So I don't mean to confuse you guys because you see 3 or 4 copies of the exact same materials. Anyway, thank you, Lisa. Everybody have a fabulous Thanksgiving, and we will see you on December 10th when Judge Winery and Crystal do their thing. Okay, take care. Bye.
Bye, everyone.